The Democratic Alliance has argued that the Employment Equity Amendment Act gives the Minister of Labour draconian powers to implement one-size-fits-all legislation across provinces. The party wants the entire Equity Amendment Act declared unconstitutional.
Is not the particular subordinate legislation or targets that have been promulgated in any particular case. They all, and that's why in 014, the notice of motion, we in para 2 want a declaration, if you're with us, my lady, and you declare the Amendment Act unconstitutional and invalid, whether in its entirety or separate parts of it, then as a consequence of that, we ask in 2 that any enactments promulgated in terms of 15A be declared unconstitutional.
In its heads of arguments, the Ministry of Labour refuted allegations that the Act targets certain minority races. Advocate Nalane says no one will be fired or hired to meet the targets of the Employment Equity Amendment Act. On Section 15A, he also refuted the DA's arguments that the employers will no longer be able to make their own employment equity plans.
There's no quota either as required or as defined by the constitutional courts, the constitutional court in the various judgments. The measure is flexible because it talks about targets. And so we'll argue that on any conception of the standards laid out by our laws and jurisprudence about how to evaluate the constitutionality of a measure, legislation, that it passes all those tests. We will also argue that there's no violation from the Dawood principle, that the Act introduces a measure which is placed in the hands of an executive, the minister, to do that which he's allowed to do in terms of the amendment, the purpose of which is to support affirmative action, as he is entitled to, as in fact is enjoined to do so. One thing that must be borne in mind, my lady, is that we're not dealing here with the targets which were drafted at the time when the matter was started and which have gone through various iterations. That is not the basis of the arguments that the leadership or the decision that leadership must make. The question centrally centers on the legislation itself. Does 15A contravene any of the constitutional requirements? Not the targets which have been set up. 15A creates a framework. 15A is not the targets themselves. And so one cannot transpose what the targets say in either draft forms. That because the targets as constructed is unconstitutional.
The Congress of South African Trade Unions, COSATU, has come out in defense of the Act, citing that the black majority is marginalized from the economy, whilst the ANC also defended the said legislation. Samkele Masego, SABC News, Pretoria.